Good. All right, so I would like to call to order the Village of Newport zoning board of appeals meeting on October 8th. Anyone like to motion for that?
Motion.
Second. Vote. Aye, okay, anonymous. All right, so the first thing, where I'd like to motion to approve the ZBA minutes of August 27th and September 19th. Did anyone say anything weird there? Everyone's good with them? Good, okay, so I'd like to have a motion to vote on approving the minutes.
Motion.
Second. Okay, vote. Aye, okay, that passed unanimously. Village board updates, do we have anything? No? Good, okay, awesome. Director of Planning, Zoning and Code Enforcement, any updates on that?
No, nothing good.
Cool. Public hearing, so the first one is for the side yard setback of 160 Union Street. Is anyone here to talk about that? Okay, sure, come on.
No.
Yeah, take down, take a seat.
I'm the owner, Jeff
Oh.
Llewellyn.
Okay, this is the public hearing, you don't have to talk now.
Okay,
We're gonna talk to you in about 5 minutes. Do
okay,
you wanna do it then? Is
yeah,
anyone else here to talk about this?
I'm sorry.
No, it's fine, this is totally normal. It's totally this is totally normal that no one wants to talk about anything. The next one, there'll be people talking about this, yeah, this is totally normal, okay, so no one wants it, going once, going twice. Okay, I motion to close the public hearing for 160 Union Street. Okay, good, vote aye, all right, good, that's closed. All right, so now we're gonna review it and go through the four factors. Four factors. So, do you have anything, yeah, the 5 factors, do you have anything you want to talk to us about before we start?
Not really, I think Sal, who was here previously, covered it well,
Okay,
from what I understand, and I'm just finally back in town, so I'm
Yeah.
sliding back in.
okay,
Take over my,
so you're the owner?
I am,
Okay, all right, you just, yeah, I saw it, it didn't look.
Yeah, there's, yeah.
I guess, and my only question, I guess, is really to you as board members that more experienced than me. We talk about these setbacks, I understand it's only 2 feet, less than 3 feet
Yeah.
in this case. If we make it, when we make exceptions here, then I always worry about the slippery slope. Where do you stop when somebody comes in at 4 feet? Well, it's only 2 feet beyond what this person is asking.
Yeah.
So what is in the practice and,
Oh, man.
I'm just.
I miss Anthony now.
I'm just a little, I am concerned about that.
No,
I just, to make an exception, say, well, it's only 3 feet here, and then somebody else comes in and says, well, mine is only 6 feet. Well, that's only 3 feet more than the 3 feet we granted today. And
Yeah,
Right.
You kind
you
of,
have to sort of look at each one individually. And Anthony used to love to talk about this, he would start with it, and he would always say. He would always talk about that, 1 foot might be a lot, and 100 feet might be nothing. Cause it depends, it all depends,
I personally have something that I take into consideration for myself, if there's something that makes it not an ordinary situation, then that's part of the reason why we're looking at it. So in this case, the fact that there is a considerable amount of lawn that is going to be untouched before his property even starts, to me, it's something that I'm taking into consideration for my own. So I like there to be something that I can like hang my hat on, to be like, this is different because.
and again, I just, for me, it's difficult. I thought about this since last meeting.
Yeah.
When we made,
That's my thought.
the code is the code, and now we're finding reasons to, and I just, that's always been my concern, the slippery slope you go down, and I think maybe that's just my background experience and,
yeah,
the world I come from as well, it's always a concern for me.
I think too, I think the thing that makes this property not too much of a concern for me is because it's a corner. So 16 feet setback between neighbors is different than 16 feet to the corner of the street, you know what I mean?
They'll have the additional.
And then they also have another 20 feet of dirt after that. And so it's sort of like, that's why you can sort of look at these things and be like, oh, it's different than that. That's where
the extra circumstance for me that makes it a fungible precedent setting. So the next time someone would come up and there's slightly 3 feet to, we're asking 3 feet too, we can get 3 feet before, well, this time it doesn't have 20 feet of additional lawn, it's like.
And if it did, I would probably be comfortable with.
I would
I
probably-
see each of you were saying you're comfortable, I just, you know, to me.
Right.
There's nothing about that in the law in and of itself and then, you know.
Yeah,
Understand.
the exception of the fact of the reason being.
The way I see it is, we set the precedent of we're setting a 3-foot variance, and that's a precedent that we can stick to later on. And, you know, those precedents can stack up, but the next time when it's like 6 feet, it's like, okay, it's like 3 foot more than our last
Yeah,
precedent,
that
but we
is-
still set a precedent of 3 feet. And, you know, it still rests on us, but let's not set any further.
Plus, the great thing is now that you guys have joined the board, you can vote no.
No,
And we like totally, that's totally fine, like if you think it's too much, then do that.
I just, you know,
And it,
I'm not, it's not.
sorry, it's probably too nervous, so.
It's just that, you know, additional, not necessarily,
Yeah.
feel comfortable with, you know, deciding, you know, looking for reasons to say yes is, you
Yeah.
know. It's, to me, the codes is pretty specific.
Yeah, if in my mind with this specifically, this is something to where the code. Is a law cut and dry, right? But it doesn't state anything different about if it lines up to. A corner lot or if it's next to a commercial property. And so to me, these are things that become extenuating circumstances to where maybe all of the little details aren't filled in, and that's why we're here, I guess.
Yeah, and because because some of the village laws are not written terribly well, that's where.
Well, I think that means to me, I think it's then incumbent upon the, you know, the board itself, or the board or whoever to, you know. Be more specific in those laws or allow for some of those other considerations to be made. You know, when it comes to, you know, I understand our role, again, just, I've been struggling with it and I'm just, you know, I'm not confident. Yeah, that's all.
The one thing I can add is. The whole purpose of the zoning board of appeals is exactly that, it's that a citizen gets to appeal to you for their, as was said before, their specific circumstance. Because in general, land use laws are written very generally, they're never going to cover every single issue, you would have war and peace.
No, I get that. I mean,
But my
it's
point
like,
is-
you can't let
Yeah.
everything that goes on.
Right, but I'm just trying to explain, you're not really setting precedent, because each application, now if you get another one exactly similar to this. With, then you could apply the precedent, but the next application doesn't have the frontage on the road.
Sounds like we're talking about qualified immunity in the Supreme Court.
And
Yeah, but the purpose of this board is to view the circumstances. And to say, yes, it's a reasonable ask, or no, it's not.
as far as even with the precedent thing, like I would want to, if someone was like, you gave this and we're like, oh, I'm on corner lot 2, I want to see this and that kind of thing. Even the busyness of the street, like all of those things can be factors that like. To where you factor in the side yard setback, like, okay, so there's going to be activity on the side of the property, or we putting somebody, you know, to, I guess. To where you said like maybe if it's written so that it covers, you know, eventually could cover more of those things. I think that's what we are. It's written that if those things aren't covered, then we discuss them and sort it out.
And we've said no to a foot or two, and we've said yes to
Yeah.
I think we said yes to 36 feet once.
Yeah, on that, that's the,
Well, you so we
Yeah.
agree with it, obviously,
Yeah.
in our other matter that we're gonna be looking at today, there is
Yeah.
discussion about setback, and we're not talking about.
Yeah,
You know, we're talking about similar distances,
Yeah.
and that is an issue that we're, you know, holding on to, so. Difficult for me to be, you know, just trying to get comfortable with the idea of that, reconcile that inconsistency.
I find it interesting, it may be easier to explain like my process in height variances a lot, because a lot of that goes into the aesthetic of the community. And which is something that's hard to even.
Well, not hyper, we're talking setback.
Right,
It's other stuff.
but yeah, that's what I'm saying, is I'm just talking about like when there's exceptions and saying like, okay, the rule is 33 feet, but why did we want this building to be 37 feet? And we said no to that one that wanted to be 35 feet. Like there's like sometimes factors that you can't even necessarily explain, it's like aesthetics and designs and feel of the community.
There's just human aspect, so sort of living in human aspect, more human in its nature.
I hear, I hear it, it's just,
So that's.
in my world, there, that.
It's your world is way more black and white, you know?
Sort of
I
thing.
have a couple of suggestions, which, we can put at any point. Background as a police officer.
Yeah,
Well, a couple of things then. First of all, police officers very often will get into a situation and there will lots of time and you won't strictly apply.
well, you
for
had,
that.
again, I get the discretion, and I'm talking, actually, what I'm referring to is more along the lines of, when I'm talking about labor issues, things like that, not even related to the administration, the application of the law in terms of on the ground. When you make certain exceptions, you can come up with reasons to justify them, and I'm not saying it's wrong or in that I don't want to do that. I'm just trying to be comfortable with that
Let me give
idea
you-
and what the role is here. Versus what my experience.
With the police officer, you establish the kind of the rule that there's discretion in every circumstance. Now we'll talk about discretion here, and let me just suggest this. As was, I think some folks said before, the zoning law, we have certain tools, but what the zoning law really tries to do is to protect the local environment in terms of quality of life and the representation of the community and things like that. And though, I'll say two things. One, as was observed before, the particular rules of 30-foot setback, 20 feet, will not necessarily be the best fit in every circumstance. The village board is never going to get that completely right. The second thing, which may give you a little bit more comfort, is that the ZBA, the existence of the ZBA is built into the zoning law and has been since the beginning of zoning laws. People were nervous about legislating what the local environment was going to, by creating these laws, unless there was some safety valve. And so it's always there. It's part of state law. It goes right back to the very beginning. And so the safety valve function exists for when the strict application of the law perhaps a little bit too deeply into the landowner, and it's your job to figure out if it is cutting too deeply, with comparison, not to the strictness of the law or the law itself, but comparison to the neighborhood that it's trying to protect. So your job is always going to be balancing how deeply it's cutting into the landowner's ability to enjoy his land with the protection of the neighborhood. And that is just, and if you're nervous about, giving yourself the authority to just suspend the law in a particular case, you should understand that that is the structure of the law. That is built in for you to be able to do that, because it was never understood that these laws of setbacks or whatever else are necessarily going to be optimal for every situation.
It's also why there's 4 or 5 of us, like Sean pointed out, like.
That was awful.
Yeah.
I hated when it was a dictatorship. I hated that, because it puts a lot of stress on people, because you should be able to vote no and not put out about it. I think I'm the only one who's ever voted against the board.
We have some deadlines that we
Yeah,
got through.
like it's
and
been-
kind of thing,
But I would love another person to do it. You're more than welcome.
I just got one other question in relation to this project. Is there any issue with expanding the footprint, so for impervious surface and in terms of percentage on that piece of property?
That's the check.
Excellent question.
It's still below
Yeah.
the maximum. So,
Cool. All right, so,
that's shown on the site plan down in the bottom right corner,
Okay.
or left corner.
I didn't see that, so I apologize. Thank you.
all right, so the 5 factors, neighborhood change, whether the variance,
Close the public hearing?
what?
Can we vote to close the public hearing?
This would go outside of the public
Yeah,
hearing. We already closed it.
We already closed it.
Yeah.
Yes, we do.
Okay, do you have anything else you wanna, no, okay, so we're just gonna go with the 5 factors. Neighborhood change, whether the change will create an undesirable change to the neighborhood or harm their nearby properties.
I don't believe so, and I think that the second part of that is what makes this a little different for Ramses than some of the other ones. It's that it will not.
Yeah, I find the change to be manageable. Alright,
No, I don't think that the change will harm the neighborhood. Again, this has been part of my. Fault.
Yeah.
I agree.
okay, learn alternative methods, whether the applicant can achieve their desired benefits through another feasible method.
I mean, we spoke with, who did we speak?
Sal, he's the architect.
The architect, and there were a couple options he looked at, and this seemed like the best way to achieve what.
He said, like, well, last meeting, he said the other options would have also.
Would
required-
still need, yeah,
Yeah, and also too, I hate when. This is just aesthetics, but I hate when houses have jogs.
Yeah.
You know, like when you get this L shape that becomes in
when you
view.
can tell in addition.
Yeah, and this seems to be trying to keep to
Avoid that.
the house and
Right.
avoid that and make it look a little bit, so. Yeah, I think so. Sustainability, whether the request or variance is substantial, it's 3 feet, sounds, well, it's 3 feet.
Yeah, I hate this question
Yeah,
because
It's also be negligible.
Yeah, I don't think it's hugely substantial, but I don't know how that you would. Pound of 3 feet,
I would say because of the other factors that in this case it is a reasonable. amount.
Yes. I think because there's so much extra land in there, it's not a huge deal. Environmental impact, whether the variance will negatively impact the neighborhood's physical or environmental condition, I don't see. Any reason to put. Yeah, I'm not seeing that either. Is it self-created hardship where the applicants create the hardship they're seeking to address?
And this is a fun one where I get to say yes.
Yep, I would agree with you. Let's say yes.
Self-created.
That's
But that's why I need to take all of that.
Yeah, okay, so,
And addendum to the 5 factors is always whether the requested variance or the one you're considering voting on you are is the minimum necessary to accomplish what you need to do.
I would say it would be because the extension is how many feet? 12 feet?
It's 12, yes.
Yeah, so to go to 9 feet would,
Okay.
I have an 8-foot porch and it's hell. And it's awful, it's like, it's so annoying if it was another 2 feet bigger, like there's certain distances that.
I think it falls into that same category to where like it's self-created, like it could be smaller, you could not do it at all, but. If it's something that's being done, I think what the way that it's being laid out is reasonable.
It's got to do a reasonable minimum, yeah. Okay, So the next step is we construct walls.
Yeah, well, we can
discuss this.
just vote on the variance and all that up.
Okay, I'm not seeing any problems with this, you guys, any environment flags? Okay, so, all right, this, the motion to vote for, to approve. To approve the variance for 160 Beacon Street. Second.
Yeah, motion.
Okay, good, should we go in order?
Sure.
Cody,
Yes.
I'll vote yes.
Yes.
No.
Okay, cool, all right. So you are set.
Okay,
Okay, and you'll get a write-up on this. It's not official until the next meeting.
okay,
Okay, so the lawyer's gonna write it up for us.
sure,
We'll approve it and they'll have approval, but you're good to go.
perfect, thank you.
Yeah, you'll get a written copy and then you can continue now with the planning board, good review. Now that you have the variance.
Okay, all right, awesome. Okay, that was it. All right, so continuing of the public hearing, so this is for 7 Prospect Street. Who would like to talk about 7 Prospect Street?
We've got 3 people signed up.
Cool,
First is Allison Nash.
okay.
First, I'd like to thank the members of the board for your careful attention to the concerns that my neighbors and I addressed in our statements at the opening of the public hearing. I appreciated the clarity in which you laid out the decision process. I now want to address some issues brought up by members of the board and by Mr. Gordon. One, definition of family. The definition of family in Village of New Paltz Code includes a statement that, quote, in the event of any conflict between this definition and the definition of family, as it may from time to time be established by New York State statutory or case law, New York State law shall prevail. In deferring to New York State law, the village does not restrict family to blood relations or to the number of unrelated people living together as a household. But note that New York State law, case law, does not therefore abandon the notion of a definition of family for dwelling purposes. The point of LUO 5 is to devise a definition of family that is inclusive of non-traditional families and at the same time recognizes the importance of preserving neighborhoods that are zoned for families. 10 pages of case law are presented to do just that. What they have in common in defining family is presenting evidence that household functions as a family. That is the quote, factual and functional equivalent of a family. Factors include, quote, being a single housekeeping unit, more or less permanent living arrangements, and stable rather than transient arrangements. Rentals by the room clearly do not meet these standards. The case of the city of White Plains versus Fedioli specifically noted that a group of college students was not the functional equivalent of a family. Mr. Lucchese asked if there was case law addressing the definition of family subsequent to the 1974 White Plains case, which I thought was a good question. So I noted the date of LUO 5, and it's dated March 2021. And therefore includes definitions that were still standing as of then. I did a quick web search of White Plains versus Fedioli and found more recent cases in which the decisions were that decision was substantiated. I'm sorry, which the decisions were substantiated by the White Plains case, and I've attached this. In particular, Grodensi versus the City of Cortland, May 2018, ruled that, quote, a unit in which the various occupants act as separate roomers may not be deemed to be occupied by the functional equivalent of a traditional family. Northwood School versus Village of Lake Placid, 219, found that households in which the, quote, the identities of the student residents would change from year to year, that no student would reside in the property for more than 2 years, unquote, was not the functional equivalent of a family. As New Paltz Village Code specifically defers to New York State case law and has clear-cut 1 and 2 family districts, New York State case law must apply. 2, enforcement. At the start of the public hearing last week, just before I was about to speak, the board presented a statement about the village's enforcement of the definition of family. It was stated that the village was not in the business of seeing who was related to whom or peeking in windows. Thank goodness for that. But that is not our position. My neighbors and I were specifically addressing the expansion of a non-conforming use. As we are a designated 2-family neighborhood, where we have settled and know one another and one another's children, we regularly observe the comings and goings of the changing tenants at 7 Prospect. At the opening of the public hearing, several people submitted statements or spoke about this. In my own notarized statement, I stated that I had spoken to several of the changing tenants over the years who told me that they rented by the room. And a tenant who moved in this semester told me that he did not know the other tenants. A functional family clearly knows its members. Thus, there was no need to peek in windows or confront people about their relationships. Neighbors attested that the house at 7 Prospect served as rentals by the rooms for college students at the time Mr. Serta submitted a plan for its expansion, thus expanding a non-conforming use. 3, jurisdiction, 60-day window for appeal. Board members aptly presented various difficulties with the 60-day limit, such as the date of the issuance of a building permit is not publicized. When approved by the planning board, the plans for 7 Prospect were not complete. Several ZBA members stated the plans were poorly drawn. If changes are made after planning board approval, how would the public know? At planning board meetings, many neighbors had spoken and or submitted statements about their concerns, including about the negative effects of having short-term rentals by the rooms. Ms. Benson, the planning board lawyer, specifically stated that the plans were for a two-family house and the issue of who would eventually live there was an issue of enforcement. She also said that the MCO would make sure the entire plans were in compliance before issuing a permit. Given all the ambiguity, an appeal could not be submitted until it was clear just what the MCO was approving. I also want to point out that once the site plan was approved by the planning board, I submitted a complaint to the MCO on June 26th of this year, before construction began. My complaint addressed the expansion of a non-conforming use. His reply on July 5th addressed the building code, stating that the plan met these requirements, but he did not address my specific complaint about its non-compliant use according to the zoning code. I sent a second complaint on August 1st, to which I received no reply. How does this fit with the 60-day timeframe? Thank you for listening to the tenets of my reasoning about the definition of family, enforcement, and jurisdiction. And I have my complaint and his response.
Is that okay? I'll get it to the members.
Thank you.
Thank you, Ms. Lynch. Thank you very much. The next person signed up, Christine Marvel.
I will my time, Dr. Nash.
Okay.
It's on time.
Yeah, there's no time, so.
Okay,
yeah.
well, we
Okay,
just wanted to make sure.
so you're just not speaking, okay. The next, June Wheeler.
I hesitate to follow up Allison, Ms. Nash, because she said everything so clearly. But to reinforce, I'm June Wheeler, I live at 15 Prospect Street. I am gonna repeat a couple of things that I said, but I will be brief. I live close enough to observe daily comings and goings of the occupants of 7 Prospect, whether from the front of the house when I walk my dog or from my backyard, straight across the backyard of the Nash residence next door. So I can speak to whether any families, by any definition, have been occupying 7 Prospect for the last couple of years. They have not. Instead, the house at 7 Prospect has had a new group of people living there each school year that it has been a part of the Certus Prospect Estates. The most recent group consisted of 6 young men. Remember, I suppose that maybe they were sextuplets. They all had similar builds. In fact, they were belonging to the same sports team. In New Paltz, they entertained themselves and their friends every Friday afternoon last spring by pulling out a gaming table off in the driveway, playing noisy drinking games until past dark, and then moved out at the end of May, like previous families had done. Not a stable situation. On the New Paltz, New York housing, it's New Paltz NY Housing, Real Estate and Rentals. There's a group on Facebook. You can find posts by Sam Prospect offering things like a 6-bedroom, 2-bathroom house on Prospect Street, walking distance to campus. How much do you think such a house might cost to rent? $750 a month. Okay, that's clearly not for the whole house. That's for a room, quite a deal. Number 7 Prospect is no longer a family residence by any legal definition. As a non-conforming use in a neighborhood zoned as R2 for 2-family homes, it should never have been approved to be expanded. Yet we Prospect Street neighbors who have been attending planning board meetings and now ZBA meetings for months and months, trying desperately to save our neighborhood, have been told we should have spoken up sooner, or we should have filed complaints with the building inspector or the code enforcer, or we should have gone before the village board to ask them to rewrite their codes, and on in what feels like a giant, irresponsible, unconscionable passing of the buck. The planning board in particular has let many similar situations slide. I think we all know this. And now landlords are more and more emboldened to build demonstrably illegal housing structures in residential districts with no consequences whatsoever. Please help us. And I wrote down a couple of quotes verbatim that I'm glad were said tonight. by your lawyer, zoning law tries to protect the character of neighborhoods and quality of life. Trying to balance with cutting into the landowner's ability to enjoy his land. That's not what we're doing here. It's the landowner is trying to just maximize profit, knew what they were doing when they acquired the property. And I think it's pretty much of an unbalanced situation.
Would you like to submit that copy?
Absolutely.
Thank you.
Okay,
That's the last person I have signed. Thank you very much.
good, awesome. So I motion to close the public hearing.
Motion.
Second. Vote. Aye. All right, so the hearing is closed. All right, so now.
I missed 2 seconds.
Yeah, so. All right, so. What? Do we want the third one first, or we want to discuss the final first? So it's not one first.
Yeah.
That would be the response. I mean, yeah, I mean, I'll do that, second, last and second last and second. This is.
Yeah.
Oh,
this is,
thanks, and
Yeah, you're done with the.
okay, all right, so. All right. So Terry, can you talk to us first before we start discussing other things?
Just in, there's nothing new to say really. Just in the summary, I wish to make a couple points. When the planning board voted on this in the first place, they did so. They had several members had expressed concerns about areas of compliance. And they were instructed by their attorney that those things did not really have to bother them because the law required the building inspector to clean that up before the permit was issued. So that whatever their concerns were, they were reassured by their attorneys that those concerns would be taken care of before permit was issued. And so that of course did not happen. And the problem is not simply that 212-63C was broken, but the trust of the planning board was violated too. It's really serious that all the parts of government should be able to rely on each other and trust that what has to be done will be done. And that just didn't happen. That's it.
Okay. All right. That's all right, so thanks, sir. We're just gonna discuss this amongst the board and yeah, that's all right. Okay. So
You want to do the villages, right? Yeah, security speaks now and language.
if you feel the need to speak up, you can always talk, just raise your hand and I'll have you come in, but
Yeah.
why don't we see where we're headed first?
Yeah, I'd like the opportunity to speak to the zoning board on this when you have a chance.
That's before.
Yeah.
It's technically relevant. Yeah. I don't even know, okay. Sure.
Good evening, I'm Brian Newman from Blue St. Shapiro for Borough. My firm's is the attorney for the Village of New Paltz. So, the zoning board heard a lot from a lot of different people about a lot of issues. So I just want to take the time to focus on a couple specific issues that really are beside the map. It really is the fact that the zoning board does not have jurisdiction to hear this appeal. And doesn't have jurisdiction for a couple of reasons. The first, purely as a matter of, first, the appeal of this building permit is an attempt by the appellant to basically do an end run around the planning board site plan approval. If the building permit that was issued by the building department was issued pursuant to the site plan approval. If site plans can be approved and building permits can be issued pursuant to those site plans and then be challenged, what's the point of having a site plan be approved in the first place with the requisite time for a person to file an Article 78 to challenge the approval of the site plan? If Mr. Duncan or anyone else who spoke believed that the site plan approval was in contravention of the village code, they, according to state law, they had 30 days from the time the resolution of site plan approval was filed with the village clerk.
Ryan, is the planning board responsible for the use determination that underlies the,
I will get to that, I can get to that. But
that's really what he's disputing with anything else, right?
And while the planning board relied on an interpretation from Corey Worthman from July 25th, 2023, stating that the project as planned complies with all applicable zoning codes.
Yes, you saying they're doing an end run around the planning board, would they have been able to sue the planning board? Take an Article 78 on the site plan approval over the use, the family use issue.
Yeah, well, with regards, they've commented today and in the past that their claim this was an expansion of a non-conforming use. They could have challenged the planning board's approval as being a unlawful expansion of a non-conforming.
So you think they can challenge the planning board over the zoning use issue?
Well, if they believe that if the planning board's relying on, if the planning board believes that all zoning is complied with and they're relying on interpretation of all zoning is complied with, and they issue a site plan in reliance on that, and someone feels that the issuance of that site plan was an error, they would file an Article 78 to challenge the granting of site plan approval, which was not done. So.
If just to make sure I'm understanding you correctly, you're saying that at the time that Corey Workman wrote that letter, and based upon that letter and all the other review process, the planning board approved the site plan, that would have been the appropriate time for an appeal, but it would have to be an Article 78.
Well, it will really, and if you want to go that far back, they could have, within the requisite time frame, appealed Mr. Worthman's interpretation.
That's where I'm going. That's what I want to talk to you about. Because I think that the planning board actually does not have, this case law, and this doesn't have authority over zoning use issues.
Of course, you're right.
And then if you try to sue them over that, they'll just go, it's just not.
Correct. Well,
So I wanted to follow. So the critical question, I think, if you, on your line of argument, is your argument would be that anything that Corey Worthman decided in March of 2023 should not be able to be reviewed by the ZBA based on a building permit, based on the site plan approval, based on that interpretation a year and a half later. Right?
Correct.
So the question is, here's what I'm struggling with. I guess the number one issue that we're talking about in this category is the whole question of the two-family house, right now. And I want to some extent channel the planning board's concern and the planning board's attorney's concern. At what point does the construction, the planning, the approval and the construction of this addition, at what point is the question of whether it's a family, assuming that that's a legitimate question, which I know it's a substance issue here, but at what point is that raised? At some point, they're just building, I think what Emily was thinking was, they're just building a house, and how can we know whether it's defined, in other words, did Corey make that decision based on the plans that came into him in March that this was going to be what they're calling a two-family house, but what these folks are certain at that time was going to be a situation where students are renting individually. So my question is, at what point in the process did the clarification that this is going to be rented by students become clear,
Well,
if at all?
well, my position is if they believe it's going to be used by students, they have no recourse because the building permit was for the approval of a two-family home. You know, the challenges to building permits can't be made on the fear that it's not going to be used in the way that the site plan was issued or the building permit was issued. And, you know,
So in other words, your point is that this concern is not right, it's an ultimate enforcement issue, and it's not a permit issue.
With regards to this building, which has not yet been built, being used for college students, yes, it's not a ripe issue.
Okay, does everybody understand? One of the things that the statute of limitations issue, if we're going to go back to Corey's decision, is that essentially Corey made a decision that this was a two-family house. And if the objection is students are going to rent it, that issue is not, I'm just channeling the logic issue so before the board. The argument would be that issue, the argument for Terry, let's say, that issue was not before Corey because he didn't know who was going to rent. He just knew that structure was being created. But that raises the question, and that's where they can get around the statute of limitations process. Corey never made that. The only thing that the statute of limitations is going to hook here is whatever Corey decided. If Corey didn't decide, it's going to be a later decision. We're going to say it's a year and a half late. It's got to be something Corey decided. So the question is, did Corey decide that this was going to be, that there was going to be a non-family living in this two-family house, which is the allegation? And if the answer is no, that he couldn't have known that, then we have the same question now. How did the permit that Alex wrote is functionally the same thing, although it's obviously got more details in it, but in terms of who's renting it, I guess the question is, we've heard a lot of testimony about who's renting the existing house. One of the concerns going the other way is this, how do we know this is not going to be a real family renting? And that's a concern, although I understand that people might be skeptical because of the history of the place, which whatever. The other concern is if indeed Corey, if something in the building plans did indicate that this was going to be rented by a number of individual people, then we would be looking probably at a such a limitation issue, given the arguments that we've seen.
So just in this top line that we're kind of talking about right now. So assuming whether he said it or he didn't, it got approved. Of course.
Okay.
That it was a family, whether it is.
He classified this as a two-family.
Right.
Road.
And so that's for the new addition.
Well, the new addition along with the existing house.
Right, with the existing house. So I guess what my question is that got approved, so that wasn't questioned in the appropriate time, whether we'll talk more about that, I'm sure, but. If this house wasn't being built onto. And the existing part was being rented out to buy the room. What does that look like?
Okay.
We're only here because this is being built,
Good question.
but the other thing's been functioning like this for years.
Well, whether or not there's a new thing, a new structure, the issues in the existing house are generally enforcement issues, and enforcement is not the authority of this board, and it's not the authority of the planning board. It is the authority of the building inspector, but not in writing a building permit or not. That's his enforcement job. That's where he goes out and decides whether or not to give an NOV. Now, let me go on. So generally, something like that's an enforcement issue. The fact that there's a proposed site plan on it, though, does raise some other questions. One of which, what the appellants are saying is an expansion of a non-conforming use.
Right.
Now, tell the board now, I don't believe this is an expansion of a non-conforming use because a non-conforming use has a very specific definition, which is essentially a use that was legal before the zoning code was written and is now illegal because the zoning code made it illegal. This is, in my view, something separate. This is just a property where there are allegedly violations and they're doing a site plan to, let's say, expand the use, but there's just flat out, it's not a non-conforming use, it's just violations. And so the question comes, can the planning board approve a site plan on a property where it is alleged, and perhaps there's no NOV, there's no enforcement, but there's an allegation of violations, and the code doesn't cover that, and I'd love to hear what you tell me.
If I can help clarify, I just looked at the application that was made to Cory, and it shows two single-family homes side by side. And so that is,
So the question becomes,
I'm just stating the answer to the question of how did he rule it was a two-family house? It was applied for.
Yeah.
so the.
So
I guess my
just
thought
stating
process
that.
is more about understanding like the weight of this is, even if this is built or like, can us, what does the process look like if citizen? What would make him informed? The fact that it like, is that something that like a citizen can
Are you
request?
Are you talking about the current house or the new structure?
Well, honestly, I kind of want to know.
Well, the new house is not built, there's no enforcement.
Yeah, so like, say the new structure's finished, and then 6 months later, it's clear that it's being rented by the room.
Yeah,
All of this topic aside, we keep saying like it's an enforcement issue.
correct.
Like, what brings about that enforcement? Because the other house
Well,
has been
the
allegedly.
enforcement officer would have to make several determinations. One, that it is a violation, and if we ever get to the substance on this, that would be a major question, the whole family issue. And the second is that, as I discussed before, every enforcement officer has discretion whether to enforce or not.
So not like
That's the
how-
question, because
I'm not asking why, like what his process to enforce it would look like, why would he be there? What's the process, the enforcement officer? So what,
he come because somebody complains or.
okay,
because of it.
that's.
You let me finish.
Yeah.
Either because somebody complains or because he's aware, but because he sees it or whatever, that there's an issue, he goes and investigates.
Right, okay, so that's what I'm curious about, is if.
So if that does happen, so let's say Mr. Dugan decides that he wants to inform the building inspector that he believes there's a violation.
And he has, and someone's been doing it the whole time.
Okay, so, and the building inspector says, I'm not gonna do anything about it. What is his next recourse at that point?
Typically, in this country, the discretion of an enforcement officer at any level not to enforce is sacrosanct. His supervisor can tell him to go out and get the job done, but a citizen can't really sue a municipality or the state or whatever because there is non-enforcement, because there's always issues of proof of whether this is the best, whether our resources are best spent doing this, of mercy. The example I always give is, if your kid was caught drunk driving and the DA decided not to enforce against your kid because it's a good kid, it's his bad night or whatever else, and I'm a student, and the neighbor's ticked off at everybody because the kid was drunk driving on the street, can the neighbor go ahead and sue the DA for not enforcing? The answer is no, because the DA has that discretion, every cop has that discretion, the building inspector has that discretion. They may not have enough of a budget to enforce, it could come down to that, so there's always enforcement discretion, but that's one reason why the appellants are actually, and the appellants are basically stuck in that situation, except that now we've got a site plan approval coming up, and what they're doing is they're using the site plan approval process to try to now get back into that enforcement zone by alleging things like non-conforming use, which is not, but what they're really saying is that if there's a violation on A and you're building building B that's attached to A and it's going to be part of the same site plan, you can't build building B until you clean up the problem in A. And that's an interesting argument. I've spent some time looking at it. There's no black letter law in that. And so the question is, should the planning board be, number one, well, it's whether Cory made a mistake in terms of somehow projecting that this would be inhabited by another bunch of students without looking at the previous practice, and B, whether the planning board has authority to do it. And although we may sit here and think geez, all that sounds like a bad idea, we should be able to get some hook if the building inspector's asleep at the switch. And some building inspectors are, I mean, they're, there's all different levels. The question is, what's the legal authority for this board to demand that somebody gets on top of that? And that's why I wanna know specifically what changed in terms, if we're gonna start getting into the permitting angle to get at this, I wanna know what changed between Corey Wishman's determination and what there is now. Because either this is just a future issue that we don't know anything about, or there was always enough evidence to say this was going to be used by students, and Corey made a determination. That Corey made a determination, as far as we're concerned in the village, as part of our discretion and how to interpret the law, that is a family house with, we're gonna call all the students a family, and if that's the case, then they're too late, then they should have been here a year and a half ago. So that's where this is not a straightforward decision, and so that's why I'm pleased that we can get the assistance of the parties to help us work through it. And that's the problem I think the appellants are in, is that if this is just an enforcement thing, and we won't know what's going on until that house gets filled up, in which case none of the permitting agencies would have been on top of it, including Corey at the beginning doing the zoning determination, the planning board. We don't really have zoning use authority, and then the building permit, or this was known because we could see the pattern right at the outset. Corey allegedly made a mistake, and here we are a year and a half later after the planning board has done site plan approval. So this is the hurdle that needs to be explained before we get to where the appellants need us to go.
I can't speak to what was going through Corey's head. All I have is like the documents that have been submitted. And in Corey's July 25th letter from last year, he writes of the blanket statement that the project as planned complies with all applicable loading zoning codes. So if you want to take that to mean that he's saying. Right. Well, in this case, he called it an addition of a dwelling unit to an existing single family.
And in the previous page, at least on the PDF, he had observed that the application was for a two-family home, and he didn't object to that.
Right. It can construct an addition onto an existing single family dwelling to convert to a two-family dwelling.
Right. So the way Corey structured his finding, and this is really important, because the only thing that could be subject to the statute of limitations is what Corey found, and what that original determination that was the planning board said. And what Corey said was that the application essentially was to convert this site to a two-family home, and then later on, he basically said it was approved from a zoning perspective and could go to the planning board for site plan approval. And so we would naturally read into that what we call a necessary finding. We necessarily found that this was compliant with the zoning, and given the verbiage that he used, we would presume that he found that this would be a two-family home. That's the way I'm reading it.
Yeah, and mine is right. I'm reading it.
Correct me if I'm wrong.
I mean, the way I read it is that, the application was made to Corey for the way it was, making an addition onto a single family home to, I guess, presumably be either, whether it was two single family homes or one two family home. He found that there was no issue of compliance with any part of the New Paltz zoning code. So whether or not it was two single family homes or one two family home, implicit in his statement is that he's finding that there's no issue with family.
Which means either of two things. Either he's saying, I don't know who they're gonna rent this to, we'll find that out in 2 years when they build it and rent it out, which would be ultimately a future enforcement issue and nothing before any of the boards. Or what everybody was assuming was that he was saying, I'm approving of this use, I see what they're doing, it's fine. This is a one family going to a two family, because he knows the exact same things that the appellants know.
Yeah.
And he's saying, we get it. It's fine, these are I am interpreting the code so that these are families, this is a one family going to a two family. That at least puts it in a permitting perspective so we can make a ruling on it. And in that case, what the case law and what logic and other things would let us say is that if you wanted to appeal that, it's certainly appealable. It should have been done at the time, because what happened in the years since is that the landowner relied heavily on this, invested substantial amount, and the planning board also relied heavily on it and invested all the time.
And with regards to whether it was the form or whether or not he didn't know, is case law that it says that, questions about potential future illegal use are not something that are a basis for denying a building permit or,
Well, but I mean, he could have made, but you're essentially arguing that he had nothing to reform. The fact is, he had a pattern of activity that he was ruling was legal, actually. He didn't consider it illegal. He considered it legal apparently. Right? And that's the through line and goal of this, is that the building inspectors have never enforced it. This has been going on the whole time. And he's got a zoning determination. So the only rational result of it is that it's legal.
And if his interpretation was that the renting of, renting of rooms to renting to college students constituted a illegal family, that was a decision that had to have been appealed back in 2023.
That's what's before the board. So the appellant's problem is that they're caught on the horns of a dilemma here. Either there's no use before us now in terms of what this future need to be because we haven't rented it out yet, or Corey was well aware of it and made that decision. The only argument that they could have, which hasn't been made explicitly, is that there's a legal activity occurring now, whether they ruled on it or not, and this is an expansion of that, and they can't do it. And that rule, and I'd love to hear the CEO tell us about that. That rule doesn't. I haven't found it.
Well, this is probably something that would be hard to find or prove or maybe even suggest, but do we know of any complaints about the original structure's occupancy not fitting into a family?
Got the CEO right here.
I will
Prior to Corey's decision?
find any complaints related to that.
I would suspect that given the way the community has presented itself, that they probably were concerned about this during the entire time that this use was happening. I don't know how far back it goes, but it would make sense to me that they would have brought this issue up to the CEO if it was happening in the block, and there's concerns they are expressing themselves now, but we don't have any. I mean, I think that's an inference, but no.
Right, and that's what this all is gonna be,
But I would also say the enforcement issues are not really before the board. The only.
No, I understand
The
that,
question is-
but the thought process behind what is in front of the board, structuring, because we're questioning the thought processes of the decision to some degree.
I would say the real question here is whether anything from a permitting perspective has changed between Corey's decision and Alex's writing the building permit. Because if it has, then that could be appealable because of the current permit. That's what they're essentially doing, is appealing the current permit. And the answer is, if anything in the current permit that Alex wrote was actually determined by Corey, it's probably too late. And so the question becomes, what, if anything, on this issue, the issue of the family, the occupancy, what, if anything, has changed between March of last year and the permit was July, I think the current building permit was July of this year. And if there are new facts, if there are new things that have come in, then the appellants can have some footing to stand on. But if nothing has changed, other than the planning board crunching this all and drawing it up and shipping it out, then the question is, why aren't they here before complaining about whatever they're complaining about?
And you didn't have complaints about the original residents and the gaps between Corey and your.
There's just been a continuous stream of complaints in relation to this whole property.
Prior to the.
I don't know what was happening prior to Corey.
No, yeah.
But it's been pretty consistent throughout the whole process.
Okay.
And I don't have full facts on this, and I'd love to hear what the parties have to say, but my crunching, my view of this is that I don't see that anything on this issue has changed between then and now. For example, if this new house was being built with 5 different bathrooms for 5 different bedrooms, let's say, that would be some evidence of, okay, now we know what's going on. That's something that maybe was before Corey, that would have been before Alex. If there was 5 kitchens, if there was 5 entrances, if there was a clear statement by the applicant that they were going to do this. You would have had more evidence and they could have come in and say, now Alex should have known about this, or maybe he didn't. Now, there's evidence
Right.
that came.
And that's why I'm curious if, like, we were talking about the enforcement issue, if there was a situation between Corey's and the current one to where it would have been impossible to not.
I would suggest that we would, I mean, my guess would be to assume that the issue of the alleged non-compliance of the people in the existing house was known to the parties all throughout this process. I would have difficulty thinking otherwise. The question becomes is, did anything come in on a site plan and building permit level that adds to the knowledge that Corey had that would therefore be the basis of an appeal on Alex's building permit?
Right.
And at this point, I haven't seen anything, and at this point, I'm guessing that there isn't very much of it, but I'd love to hear somebody dot that on and cross that T.
Yeah, no, I haven't seen any changes to the site plan.
No new evidence about this project that would make it clearer to you than it was to Corey that there are gonna be a number of undated students in there.
Yeah, no.
That, to me, that would be the most important factual piece that would need that would give us some level of jurisdiction to ask Alex, why'd you do that for?
Well, and that's basically what I'm asking is with the enforcement thing, it's tricky because if it was added and it was checked.
This is the. Okay, so there's two issues here. One is family and one is the plans.
The
Okay,
plans?
the plans, because the plans were different. That was the two issues.
Okay,
All right, let's go with plan ones first.
you know what I'm saying is the plans for the addition are different now than they were before Corey.
Yes, or,
Well, Corey didn't even have plans.
and Corey,
He had an application.
he had an application, I don't know.
There were plans with the application.
Yeah.
But not for.
Okay, but there's basically,
Plans are different from the building.
yes,
Yeah.
and so there's things like that. All that stuff is, as far as I'm concerned, that's so long ago that if you wanted to stop it at that point, you should have done that a long time ago. And I'm also looking at this other thing, like, this should have been done before the building was built. The building's built, so it's there, it's in the wrong space. And it's bigger than it used to be. But this project is pretty well developed, and we're going back to the very first step. Which had ample time, and this is a planning board issue, this is the planning board should have taken care of this.
Well, the plan, again, if you're making an argument about the zoning use, one family, two family, commercial, et cetera. And sometimes there are disputes about this is and what it is. What the courts say, right, for better or for worse, is that the planning boards just don't have jurisdiction over that stuff. In fact, they don't really, what the courts will say when they're being sloppy is that the planning board doesn't even have jurisdiction over zoning. That is for a separate side of the village administration. It would be for the CEO and then on appeal to this board. The planning board has to accept the zoning. So the issue of the family who's going to be there is not before it's not really before the planning board. In fact, arguably, the developer can tell them, you planning board have no authority even to question me on zoning use issues. Here's my site plan proposal, deal with it. And so at that point, the appellants start to have more of an argument because they did say it to the planning board, and the planning board said, the planning board viewed it as on the enforcement side. That's why Emily chose to look at it according to what was presented to us by one of the members of the community, said essentially Emily, who's the planning board's lawyer, said, well, that's going to be a future enforcement issue that we don't know anything about. So she looked at it that way. But I'm trying the best I can to give you as much credit to the appeal as possible to figure out how is this a permitting issue. The bottom line is the planning board can't deal with that. So even if the planning board looked at the plans and said, we know what's going on here. This is going to be a zoning violation. We see the number of bathrooms, we see what they're doing. They don't have jurisdiction over that. Now, so the best that we can do here for them is that if this information somehow came in, and I don't say it did, but just theoretically, if it did, the planning board said, we can't touch that. We just got to do a site plan approval. Now it's coming back to Alex, and he can't. He's the zoning guy. So now all of a sudden it becomes, if there's this new information, and this is just completely hypothetical again, it's theoretical. If there were this new information that makes it clear that this is going to happen, that these students are gonna run this out, the argument would be, Alex does have that jurisdiction, he's the zoning interpreter, so he can say, oh, you know, I'm now seeing a zoning violation here. Under those circumstances, this appeal might be fine, because there's no other instance, like you said, in this whole year and a half, they should have done
But
something.
he would have to start it.
Well, or what they're alleging is he wrote it, instead of starting it, and this is not an enforcement issue now, this is a permitting issue. Instead of, as you put it, starting it, the allegation would be, he wrote a building permit. And that was not legal, and he should have known that, and that's why they're here. But that all depends again on new information coming in that Cory never saw, that Alex saw, and again, the planning board just doesn't have jurisdiction over the zoning classification. So I'm asking again, was there anything new that came in that should have signaled to Alex that that's assuming, as if we were to get to the later argument that this indeed is a zoning violation, there's obviously going to be a lot of give and take on that if we ever get there. But the question again I want to know is, was there new information that should have tipped him off that there was going to be this alleged zoning violation? And at this point, I don't know what that is.
Would you allow me to reply on behalf of the village? So just one point to that. The planning board actually does have one set of recourse in that they can do exactly what the residents have done. The planning board can look at a zoning referral and say, we disagree with the zoning referral and can appeal it to your board as the zoning.
Only within 60 days.
Correct, but I'm just pointing out that when they receive that referral, if they believe that the referral was wrong, just like any resident can, anyone can appeal the CEO decision. I just wanted to clarify, it's not.
But that actually, Mike's point actually underscores how little independent authority the planning board has. So the bottom line is they would have had to come to this room as an appellant, essentially arguing against a coordinate branch of the village that they're before a third branch of the village, and they would have had to do it within 60 days. Essentially, they would have had to have done it by June 1st of last year, and who knows where they were at in the site plan approval process by then. So that actually underscores how little authority the planning board has in a situation like this.
Just in terms of dates, it may not even be maybe a moot point, but you keep referring to July, you keep referring to March. I'm looking at the two letters. The letter dated July 25th is where Cory says the project as planned, it complies with all zoning codes. The March letter just simply says that he's in receipt of an application and.
Okay.
Yeah, the March letter is basically says he's received the application and the application is ready for review.
By the planning board.
Yeah.
Well, so that's when I interpreted that as referral to the planning board.
It said there's some things that need to be done, and then in this last one, the one in July, his last point is the project as planned complies with all applicable local zoning codes. It doesn't.
Okay.
That language does not exist.
So
That second letter came at the request of the planning board asking him to review what was in front of them, I believe.
Was it?
Is that correct, Alan?
I believe so.
Yeah.
Would it be the family issue?
I have no idea, I wasn't in.
I'm just saying that language is not in this March letter,
That's right. Right.
The March letter is the way the process works is somebody applies to the code enforcement, zoning enforcement officer, says, I'd like to do this use. That he reviews it against the zoning code, says, you know, you need site plan approval, you need special use, you need whatever. That's the start of the referral to so that's what's called the determination letter. Where
which one, March?
The March one.
Okay.
The second happened at the request, I believe, and I can go back and try to find, of the planning board is this application code compliant, which could have originated from a question that came up in a planning meeting.
So they've heard an interpretation.
So the second letter is not a normal letter, but it was a secondary confirmation.
But
The first was the actual referral.
Our contention that letter basically was a binding determination by the building inspector. In July, there was a binding determination that there were no issues with the code. To the extent there were any questions about compliance with the code, whether it was, issues of setbacks or whether it's a family, anything like that, based on the information he had, it was code compliant.
Fair enough, but if there was no information coming in that would indicate a code violation, then we can't pin that on folks.
And that's what I keep coming, and maybe explain to me if I'm thinking about this wrong. But that's why I keep asking, 'cause the enforcement thing is a whole different situation, but if a request to look into the enforcement of the original structure happened between July of course.
That's not what you talking about the planning board request?
No,
Or you talking something?
it's just like a citizen who were to request, wouldn't that qualify as new information?
No, that's just, the citizens don't have information, they just request.
No, I understand that, but the CEO would have been.
No, well, again, I'm assuming that Corey was not absent knowledge of what was going on, he knew. And so, if the citizen said, hey, wait a minute, look at this. That is, by new information, I mean, something that Alex should have picked up on.
Okay,
That's
well, we keep saying assuming it's Corey, and I just wanted to know if there was an actual, request, a document of it, something substantial, but.
And besides, here's his best answer to your question.
We might have some.
Because of the citizens.
Do we have some information, Tim?
Yeah, I would love to share some information.
Okay.
So you absolutely do have new information. So in April of this year, the village board issued a position statement about the appropriate definition for family. You all should have received it. The position statement concludes by saying the village board may elect to update this definition of family in the future, should such an update be deemed necessary in order to protect the personal privacy and freedoms of residents. So I would like to share with this board that I intend to update our village board agenda tomorrow evening and include an updated appropriate definition for family.
And to be clear, that definition of family would render the use legal?
No, I'm sharing information that the village board issued in April about how we would like, based on the current wording of the definition and the current case laws that were reviewed by our attorneys about how the definition of family should be viewed. So we will not have to deal with this anymore in terms of any sort of curiosities about how anyone should be defining families. We will make it crystal clear in village law.
Okay. I don't know if that
Yeah.
I don't know if that made that less confusing or more confusing.
Well, please read the position statement from April of this year.
Yeah.
We're not discussing.
I make a point of information.
No.
We're not discussing it, we haven't even gotten to the definition of family.
Yeah, we're not.
Whether or not that matters.
Yeah.
We're talking about just the timeless of the.
We're not even doing that. We're, okay, so we need to just step back here for a second. The law on statute of limitations is pretty clear.
If Corey, whatever decision Corey made,
Yes,
should not be able to be appealed a year later.
yes,
For
okay.
a bunch of reasons.
Yeah, because you can't go back after I mean, they could then in theory go back and say, the plans for my house that's 200 years old weren't drawn correctly and the chimney's in the wrong spot and you have too much of this and you have a parking issue and you have an extra this and you have an extra that and you now have to look at your house now. Like there's a reason why statutes of limitations are here.
Yeah.
Okay, so let's just talk about that for 30 seconds, okay? I think we all know that Corey made a decision over a year ago.
Yeah.
Right?
Yeah.
And this didn't this definitely was not in that 60-day kind of thing.
There was no appeal to this.
Yeah, it was not an appeal.
It's July. So
Statute of limitation is glorious, it's
The
close.
statute of limitation, I think Corey ruled on, I think it's very clear that that already happened.
Right, unless, like,
So it's not.
unless there's some new information that.
Some new information.
But no, by definition, Corey would not, I mean, it would be something outside of his ruling and
Yes.
something that Alex should have picked up.
Yes, and Alex, have you changed your mind on this at all? Or, no? Okay, so we have a building inspector who made the decision a while ago. And until now, there's been no change in the building inspector's opinion on that. Right? Right, we're agreeing on this, right? Okay, good, I just need, give me a thumbs up or something, okay, I'm trying to, so to me, this first one seems rather clear. So anything that has to do with that, it's too late. Okay, because you just can't,
Yeah,
like, are we,
I,
I think we just have to talk about that before we get sucked into everything else.
my only thing that I kept circling back to, is I wanted to be very, very clear that there wasn't something that fell into that category, and I think
I think we've completely, I think we're getting off the weeds here, we're not missing the big issue. So the big issue here is, was this filed in a timely manner? And I think the answer to that is no. So,
That would be my recommendation.
okay, should we need to vote on this, or?
Yeah, I recommend voting on it because that will dismiss, the number of the.
Okay.
All right,
So-
so that eliminates the family thing altogether for us.
The family things, that, I think that's,
And then.
yes, whatever Corey, that will eliminate anything that Corey necessarily decided, or say decided.
Yeah.
Can you word the motion as to what it would say?
Okay, so
With full statute of limitations.
So we are going to.
Are we not even seeing it then?
That's right.
Yes, so.
The motion would be to dismiss the causes of action in the appeal that was decided by Corey Worthman last year, or were necessarily decided by him, which I can explain, last year in either March or July. Dismissing them from the appeal here, and we will not get to them, because they were decided, necessarily decided within the year.
Yes.
Yeah, so ultimately,
Now-
because of the statute of limitation, we're not even.
Okay, so let's vote on that first, we knock that out, okay? All right, so we are voting to, we are dismiss
As untimely,
as untimely.
any claim in the appeal that was decided or necessarily decided in the CEO determinations last year.
Okay. Motion?
A motion to vote? or-
Yes, motion to
Yeah, motion.
Seconded, okay, we'll go roll call, Cody.
I gotta think about which way it was phrased.
Just
You want me
motion,
to read it back to you?
it's a motion to dismiss brought by the CEO that we would be picking the
Yes.
motion to dismiss.
Motion to dismiss.
Yes.
Dismiss as untimely. That's correct. Yeah.
Yeah.
Motion to dismiss.
There's certain, those claims is untimely.
Yes.
Yeah.
Vote to dismiss.
Motion dismissed.
All right. Now. What's left?
Well, the question then becomes, what was in the building permit that's being appealed that was not decided by court? And there are a number of other claims here that relate to, pieces of building permit that, that actually resulted from the site plan approval and new plans, et cetera. So that's still on the table before us. But there are two other sort of jurisdictional questions that we may want to consider before we actually sink our teeth into those. One of them is what was brought up about some of those moving pieces are under the fire and the building code rather than under the zone code. But there's a second one that I want the board to consider. And that was a suggestion, which I think was only brought up in the more recent document, may have been brought up before by the village, that the building permit, the specific issues, especially if you're talking about actual, specific things like you didn't look at this or one of these things in the wrong place, is currently moot because number one, the building permit as we sit here now is suspended. And number two, more importantly, the planning board is considering an amended site plan approval, which if approved, would result in a new site plan approval, which would result in a new building permit. And so whatever the complaints are about the existing building permit, even if they're true, even if we would agree with them, ultimately, Alex is gonna have to go through a new process for a new building permit, assuming the planning board grants a new site plan approval, which I'm not sure how likely it is, but certainly not, outside of reasonable possibility. And once the planning board does that, whatever this board decides on those nuts and bolts is we're just gonna have to go through it all over again, or if we're lucky, the planning board and the CEO will do it, granting the appellant's concerns, do it better this time. And so it'll be legal. So the question is whether this board wants to get at those issues, given the fact that the planning board and ultimately the CEO may be rewriting the whole thing.
Like, if, let's say it doesn't, the planning board, it has to go before the planning board again, correct?
They're meeting next week to deal with this.
Yeah,
I mean, with regard, we would say, to the extent that the ZBA believes they have continuing jurisdiction over certain aspects of this appeal, that it might be prudent to hold this matter in abeyance until the planning board, reaches a conclusion. Because as was said, if the planning board decides to issue an amended site plan, the building permit that was issued back in July is no longer any good. A new permit would have to be issued that was in compliance with the amended site plan.
so by the fact that he's going for a new site plan, he's opening himself up to all the complaints that the people have talked about. Except now it will be legal and in a timely manner.
Well, more to the point, assuming the appellants are correct, this would be the planning board and the CEO's opportunity to fix it.
And so who would kick that to our board to make that decision?
Let's give an example. One of the things that the appellants are complaining about is that Alex did not look at the correct plans and that they weren't complete and he just missed a bunch of information that the code required them to. Well, if this time he does that, he makes sure he knows what's coming, so he's going to make sure that he gets a complete set of plans from the applicant and a thorough site plan approval from the planning board. That complaint will have been obviated because he will have done the right thing, and without the argument whether he did the right thing this time. Next time, he knows now, and maybe he'll do it better.
If there's a new site plan, there'll be a new building permit, is the short answer.
And
So if there's a new, if they deny it, and he tries to then continue on his current site plan, then you could pick up the review.
That's right.
So what you would be doing is just
Putting
taking a halt until the planning board finishes the process. If they approve it, the building permit that was issued is non-existent because there's a new site plan, there's a new building permit. If they disapprove it, then you can just go back into your review.
So if they disapprove the new site plan, if they disapprove it, would the current stop work order remain in effect until we resolve these
Correct.
issues?
Well, no, the current stop work order would be in effect until the CEO removes it, and one of two things happens to remove it. Either they get a new site plan, or they build the building as was approved by the site plan previously, which means they would have to either take down the new building and move it, or they would have to move it, but they would have to build to that site plan.
In other words, we don't know what the planning board is going to do, but there's a reasonably strong chance that there will be a new building permit coming out of this. And a new process for that building permit, which may fix some or all of the allegations of legality.
And it's also appealable.
But yes, that's like.
It would be a
Still
appeal.
an appeal that it's an extenuation of a
Well, the use issue we've already decided should have been raised.
Right, but now they'll be able to.
No, it's the new building permit is not based on the new use.
We just decided that they could not appeal from the July building permit from this year because of that, they're not gonna be able to appeal from what a permit that's issued in February of next year.
So
On the same basis.
unless there are materially different aspects to the zoning of the amended site plan from what the original site plan was, you know. There'd be nothing to appeal regarding the code, you know, if the amended site plan is exactly the same code wise, it just changes certain dimensions or something, then there's nothing to review. It'd be arbitrary, there'd be nothing for the ZBA to review in terms of the code, because nothing would have changed from what Corey decided July of last year.
I mean, it'll be up to the appellants to figure out if there's an alleged illegality, and we can figure out at that point whether it's before us.
Show me what? What? Yeah, I think I'm going to agree with our lawyer and we should table this.
Yeah, we can table it, and I guess what we need to do specifically is, and I have not had the opportunity to do this, and perhaps we should invite all the parties to do it. They would tell us specifically whether this would, you know, take care of all of the remaining arguments or some of them, so that some agree. I don't know to what extent all of the remaining arguments would be in this category. My guess is that they all are, but I'd certainly want to hear from the appellant before we table the whole thing, if there are any that are outside of this idea that we're gonna get a new building. I think you probably, you know, conceptually, I think they are, but there was enough, there were enough pieces in the original bill that I don't know for sure.
But look, I guess with like what I'm a little confused about on still is like, so like. I'm assuming this, but the appellant doesn't actually care if it's like, if the door's here or the bathroom's here. It all comes back to the fact that they think that the crowd that this is bringing in, that's the reason.
That may be true, and you know these folks better than I do, and so you can read that in, but the fact is they've submitted an appeal with a series of claims. And we have to accept those claims at face value, one of which is, for example, the staircase is in the wrong place.
I guess I'm using all of the public hearing information where no one said anything about a staircase and everybody said everything about public staircase.
We've got,
But I think that would be under what we decided was
To not.
time was untimely, I mean, that's.
Right.
Use that goes.
But my.
even in the public hearing, there was allegations of the lot coverage. And
Right.
some, I mean,
But just as tools because they're.
I mean, they now have more rooms. So they need more parking spaces, so now they have to have 11 parking spaces if they want to build that like that. So they're gonna have to come to us anyway, because their lot coverage is gonna be crazy.
Maybe they'll change their site plan, who knows?
Yeah, they're gonna have to change a whole bunch of stuff to be in compliance. If you have 11 rooms, you need.
But in this case where it's a citizen.
They only have 9 bedrooms.
9 bedrooms and 2 houses, so it's 2 plus 1 for every additional bedroom.
well, this is where the CEO has to advise the planning board as to whether they.
Yeah, I mean, they need, I think, so I mean, the way.
No, it's 2 for the first one and then, so it's.
Yeah,
So
so
not,
2 plus 2, and there's 4, it's,
but only up to the first 2. So if it's one room.
well, there's 9 and 2 extras. Because there's 9 bedrooms and then the 1 for the building, 1 for the building, so it's 9,
The
10,
2
11.
extras fall in, the 2 extras are only if it's a single.
Total for
It's a
property,
family.
not by house.
Okay, but there's still now we're at 11, so they have 7 right now, 7 spots?
I can.
Yeah, they have like, I looked at it, and I was like, oh, that's not gonna work.
Because after,
Like, you know.
it's 2 for 1 and then if it's 2 or more.
And I'd
it's
be,
just 1.
and I'm
So it would be
I'm
9.
still waiting for to see the real. Like a legit site plan that shows where the line is, cause there has to be a survey.
Planning at the last meeting, the planning board asked them for a survey and also to stake out the property.
Yeah. Yeah, because they're gonna be able.
But that's all.
Yeah, alright.
I just feel like we're only talking about these issues because something else is attempting to be achieved.
And that may or may not be true, but the obligation of the board is to look at the complaint at face value.
Right.
And then, you know, ultimately having dismissed the issues that you think they really care about, they may not bother anymore, or they may decide that every single thing they recommend. I mean, it appears to me that, you know, they did a pretty thorough job in looking at the situation they saw before them and apprising us of every illegality that they thought was there, and they may well do that again, and so
Yeah.
we just don't know, and some of those complaints may still survive the next time, and we may be back before it again, when we don't know what's going to happen.
So what should we do at this point?
You can make a motion to table it until we see a amended site plan approval and ultimately new building permit.
Enabling the issuance of the building permit, correct? I just want to be sure I have the right word. Review of the issuance of the building permit, not that you already ruled on.
Yeah. I guess, yeah, as long as they don't get a building, they need a new building permit before it affects us, yeah. That'll be very comfortable for the board unless the planning board brings it to us.
So you'll say until such time as the planning board completes its review of the amended site plan?
Yeah.
Okay.
Yeah.
And then we'll,
And also, we're also gonna get more information in a couple of days on what a family is exactly,
Okay,
so
yeah.
that will also clear up a lot.
but yeah, we voted.
That's not,
Take
so
it.
then we're gonna discuss them.
Unless I guess it comes back because of the.
Well, yeah.
We'll have to, we have
Actually, yeah,
to, that's,
definitely not.
that's going and also where, what the amended site.
Right.
plan's gonna- Like I said, and if he decides to build a house and they approve it with 6 bathrooms, then we'll have to look at the new zoning, definition and see how. it
Yep.
works.
So,
You want me to read you with the motion?
Yes,
yes,
Motion to table the review of the appeal regarding the issuance of the building permit until such time as the planning board completes review of the amended site.
motion.
second. Vote, okay, good. All right,
All right, it's up to you guys for next month.
okay.
This
I think you're gonna go through and see what's.
This movement is supposed.
All right, I vote to, I motion to close the meeting.
I just have one, does the board want any submissions about giving their opinion as to what aspects of the appeal are dismissed in connection with Corey's letter or?
I think we're clear on.
Okay,
No, it was,
because like there's some discussion as to what elements
Well, we
the,
just, that's why we discussed the whole thing, because we knew, pending the building permit. So, probably not, it's fine. That would have been necessary when we were still moving forward with the nuts and the bolts now, the whole thing, against the whole thing, or it's offended.
Well,
so
it's
it's the planning board that's done.
yeah.
okay.
So this was the planning board, sort of an open.
Okay, so we got a motion and a second for the chair.
I'd love to.